Hello once again. My name is Victor Manibo from Wang Law Office. I'm one of the lead attorneys here at the law firm, and you are now watching the AM Show, one of Wang Law Office's latest YouTube shows.
Yes. Hi, I'm the host, Ariel. Also, I'm a senior paralegal in Wang Law Office. Our show going to start every Friday at 8 a.m. EST.
And for this show, we answer some common immigration questions from our viewers. So if you have any questions about any topic related to immigration, you can comment on our YouTube page. You can email us or you can message us online. We'll try to put together all the questions about a particular topic, and every week we're going to have one episode about that topic.
Yeah. Victor, can you give a small introduction on your own?
Sure. Again, I am one of the attorneys here at Wang Law Office. I do mostly immigration and some civil rights work and some criminal law as far as it relates to how it impacts someone's immigration status. I've been with the firm for 10 years, and I've also been a lawyer for 12 years. I graduated from Cardozo School of Law here in New York City.
Yeah. I see there's a lot of people asking the same question. Can I get a green card if I overstay my visa? So I know this is a common question. Before we actually answer this question, Victor, how do I know whether I have been overstaying my visa?
Right. So overstaying a visa is a very common problem for a lot of people who came to the United States. Maybe they came here on a student visa, or maybe they came here on a tourist visa. Those visas have an expiration date. Okay, so when you come into the country with a visa, usually there is a date by which you have to leave. And if you don't leave by that date, you are considered to have overstayed your country. You have overstayed the duration of your stay that's approved by our immigration system. So if you're in the country physically after that date, you're officially overstaying.
So some people say they got a 10-year US visa. Does mean that they can stay here for that long?
So that 10-year period, you usually hear that about tourist visas or visitor visas or B1, B2 visas. So those kinds of visas are usually valid for 10 years, but that doesn't mean that when you use it to come into the US, you can stay here for 10 years, because that's a really long time. It just means that for that 10-year period, you can travel in and out of the United States using the same B1, B2 visa. Now, every trip has a limited duration of stay where you're only allowed to stay for a certain number of time. Usually that's 6 months. But that doesn't mean that your B visa expires after that 6 months. That just means your particular stay using that visa expires after 6 months. You have to leave after those 6 months, and then you can come back again some other time for another trip, as long as that the visa itself that lasts, again, sometimes for 10 years, as long as it's still valid, you can use it again for another trip.
Okay. I heard that right now the I-94, some of them is paper I-94. If I do not have a paper I-94, how can I get one?
So the I-94 is a common term that we get a lot of questions about from our viewers. An I-94 is basically an arrival departure record. It's the record from our immigration system about when somebody comes into the country using a visa. And in the past, when you come into the country on a plane, you are given a slip of paper that you have to fill out with your name and with your information. And then the immigration authorities stamp that when you come in and say, okay, you entered using this visa and you're allowed to stay up until this date. It used to be on paper. In recent years, everything has become digital. So you might not get that piece of paper that's called an I-94, but there is still a record of you coming into the country. There is still an I-94 but it is digital and it's accessible through the CBP website at cbp.gov. Now, why is the I-94 important? The I-94 is important because, again, it's a record of you entering the country legally, and a legal entry into the US is important for people who want to apply to adjust their status to become a lawful permanent resident. You know, we talked about LPRs before, we talked about adjustment of status before, and one of the requirements is that you have been legally admitted or lawfully admitted into the United States on a valid visa. And the I-94 is the proof of that. That's why the I-94 is important. Now, you could have a paper I-94, you could have a digital I-94. Either way, that proves that you were lawfully allowed into the country, and that could help you apply for a green card.
You mentioned earlier the paper I-94 going to have the day that you're going to leave, right? So the EI-94, is that going to have a day over there telling that how long I can stay?
Right. So the I-94 paper or the electronic version, it's going to say when your stay expires or when you're supposed to leave the country, and that's the date that you have to leave. You know, again, this is typical with visitor visas, with tourist visas. If it says, for example, you have to leave by, you know, April 30th, 2022, then you have to leave by that date. If you do not leave by that date, it's going to be a problem. You will start accumulating what's called unlawful presence. And when you have unlawful presence, it can complicate your future immigration benefits. If you're applying for future immigration benefits, it can complicate whether or not you can come back on that same B visa. It can complicate whether or not you can apply for lawful permanent resident if that's what you want to do.
So what will happen if I do not leave within the time that CBP provide? Is that mean that I cannot return?
So let's say you entered the country on a tourist visa, or you enter the country on any kind of visa, and you overstayed. Hopefully, in applying for that visa, you hired a lawyer who knows what they're doing, who knows the immigration system, and hopefully before your visa expired, you consulted with the lawyer and said, hey, you know, I might have to overstay for whatever reason, right? You know, sometimes life happens and you just can't leave right away.
Yeah.
You have to consult your lawyer to make sure that, you know, the lawyer can advise you that, okay, this is what the consequences are if you overstay. Now, what are those consequences? I mentioned a little bit about you might not be able to return next time if you overstay. Depending on how long you overstay, you might be, you know, prevented from returning on the same visa. Like, for example, if you are on a tourist visa, you might not be able to come back, even though it's a 10-year visa and, you know, it's still valid and not expired. They might not let you back in. If you have unlawful presence, that's also going to be a problem. If you're applying for a green card, you might not be eligible to apply for a green card through adjustment of status through your family members. Or you might be required to get a waiver to get that unlawful presence forgiven. So, you know, it's very important to comply with the date for your authorized stay and to not go over that date. You know, unlawful presence, the word unlawful, that should, you know, trigger some alarms in your mind, thinking
you should need a lawyer
whenever
this situation happens.
Right, yeah, like, okay, I might need a lawyer for this.
You mentioned there is some consequence for unlawful person. Is there other that you didn't mention?
Right. So like I said earlier, some of the consequences are you might not be able to come back, right? If you, for example, overstay in the United States for some time, like let's say less than a year, let's say you're supposed to leave April 30, 2022, and you left 2 months after that, or 3 months after that.
Okay.
So you're really overstaying, right?
Mm-hmm.
And then you leave. When you try to come back, they're not going to let you in because you will be subjected to a 3-year bar. That means that you are prohibited, disallowed from coming into the United States for 3 years after you left. So that's the penalty. Now, if you overstayed for over a year, if you're supposed to leave April 30, 2022 and you leave April 30, 2023, you will be barred for 10 years. So that's a really long time, 10 years from your departure. You have to wait 10 more years before they let you back in, if they allow you back in. So by that time, your B visa is going to be expired already, so you have to reapply again, and they might reject you because you have this history of overstaying. So those are the really severe consequences. So you won't be able to allowed to go back into the country.
So before you make any decision, better talk to a lawyer, understand what's going to be happen on you first.
Right, and just as in general, try not to overstay. Obviously, there's those limits are there for a reason. There are sometimes circumstances where you should overstay, and when you are legally going to be okay, you won't suffer any consequences for overstaying. But those distinctions, those exceptions, are very complicated, and you won't really understand them on your own unless a lawyer can explain them to you and can review your situation.
Yeah, we talk about overstay. I heard there's another term, illegal entry. What is that?
So illegal entry is also a way where someone can get unlawful presence. So let's understand those terms, right? Unlawful presence. Unlawful means not within the law, and presence means present, like in existence. So if you are unlawfully present in the United States, that means one of two things. One, you overstayed your visa, right? You were lawfully present, but that expired, so now you're not lawfully present anymore. And the other way is you're present in the US without a visa at all. You probably crossed the border illegally, without a valid visa, without a passport, without presenting yourself to our Customs and Border Protection officers. So that is the second way that you can obtain unlawful presence: overstaying and illegal entry. And again, for just like with overstaying, when you illegally enter, you gain unlawful presence, and when you gain unlawful presence, you have those consequences that when you leave, you are going to be prevented from coming back to the US, and obviously there are other consequences when you apply for immigration benefits later on.
So can I apply for green card if I enter the US illegally?
So this is a very complicated question and unfortunately, a very common scenario. We have a lot of people who came into the United States without a visa, came into the United States not through the airports or normal ports of entry, and they still have, their hopes and dreams to be in the United States, to gain lawful status, to get permanent residency, mostly because they have family members here. And so we hear this question a lot. Can I still get a green card? Can I still get a permanent residency even though I entered illegally? The answer is it depends. It depends on a lot of things, but there is a way for you to get a green card even though you entered illegally. The kind of quick answer is yes, you can, but you will most likely have to leave the country and come back. For a very limited type of people, you don't have to do that. But for a lot of people, they might have to leave and then come back. We can go into detail, but the short answer is it depends. Yes, it's possible, but it's going to be a little bit difficult.
Yeah. So is there a situation that I cannot apply for green card at all when I was illegal entering?
Well, yes. So I said it's difficult, but it's possible. Sometimes it's close to impossible. You illegally re-enter multiple times. let's say you are illegally re-enter, or you illegally enter the United States, and then you get caught by ICE, and then you get deported back to your home country, and then you try again to enter illegally again for the second time, you're going to be barred from a lot of immigration benefits, including lawful permanent residency, including a green card. So illegal re-entrance, close to impossible. There are very limited exceptions. But yeah, that's one situation where you're probably never going to get a green card.
You mentioned some immigration bar. What is that?
The bars, like I said earlier, I was mentioning this already. That's the 3-year bar and the 10-year bar and the permanent bar. Bar from coming back into the U.S. If, like I said, if you overstay your visa for less than a year, you could be barred for 3 years. If you overstay for over a year, you could be barred for 10 years. And if you are a legal re-entrant, you're permanently barred from coming back into the U.S.
Back to our question. Can I apply for green card if I overstay my visa?
So you can apply for a green card even though you overstayed your visa. It just depends on what kind of family-based relationship you have for your family-based petition. If for some people, you can adjust status, meaning you don't have to leave the country. But for some people, unfortunately, you might have to go abroad first, go back to your home country, and then do your LPR application through consular processing.
We mentioned earlier, if I have an unlawful person and maybe I plan to leave the US, anything going to happen to me?
So if you leave after accumulating unlawful presence in the US, you will probably suffer from those bars that I was telling you about earlier, which are the restrictions that will disallow you from returning to the United States. So you'd be banned from coming back for 3 years or for 10 years or permanently, depending on the circumstances. So that's why if you ever have unlawful presence and you want to stay in the United States or you want to come back to the United States, please talk to a lawyer to see, hey, how can I fix this? I overstayed my visa. Or, hey, how can I fix this? I entered illegally. I really want to, be in the United States again in the future, or I really want to be in the United States to be with my family and have a green card. How can I fix this? There are ways to fix it, but if you accumulate unlawful presence and you leave, it makes it a lot harder.
So what kind of people are going to be allowed adjusting status even after overstay the visa?
So I mentioned earlier how for some people, even though they overstay, they can adjust their status and they don't have to go back to their home country, right? So those people are the immediate relatives. We talked about family-based petitions a few weeks ago, and the term immediate relatives. Those are the spouses, the parents, and the children of U.S. citizens. So, for example, if you have a U.S. citizen spouse, or you have a U.S. citizen parent, or you have an adult U.S. citizen child petitioning for you, even though you overstayed your visa, or even though you entered the country unlawfully, you can still adjust status. You can still file your I-485 with no problem. It's an exception. You can think of it as special treatment for immediate relatives, because those are the closest family members. Those are the closest family relationships that you can have, right? The spouse, the child, the parent. So, our system of laws kind of prioritize that, and they prioritize that for U.S. citizens, right? So they have a little bit of an exception for immediate relatives who have overstayed. It's okay if you overstayed. It's okay if you were an illegal entrant. As long as you're an immediate relative, you can still file an I-485. You don't have to leave the country to get your green card.
Who is not allowed to adjust status after overstay the visa?
So those who aren't immediate relatives, they're the ones who are not allowed to adjust status, right? Everybody else that have a different relationship. If you're not, the parent, the child, the spouse of a U.S. citizen, so if you are the sibling of a U.S. citizen, or if you are the adult child of a U.S. citizen, or if you are related to an LPR, if your petitioner is an LPR, and if you have overstayed your visa, or you have accumulated unlawful presence, or if you are an illegal entrant, you cannot adjust status because you will have to get a waiver for your unlawful presence. Your unlawful presence isn't forgiven. It's not, like an immediate relative, like, it's fine because you're an immediate relative, we forgive it. For these kinds of relationships, you have to file a waiver. You have to ask the government for forgiveness for your unlawful presence. And the waiver process requires you eventually to go back to your home country and get your immigrant visa, your green card, through consular processing.
Yeah, there is different kind of situation. You better consult a lawyer to see which situation you fit. You mentioned waiver, right? That is some sort of waiver for unlawful person. What is that?
So when you have unlawful presence and you are not an immediate relative, the only way to get immigrant visa or to get a lawful permanent residency is through the I-601A process. I-601A is the form that you use for a waiver. That means an application to the government or immigration system to forgive your unlawful presence. And so what happens is you basically have to convince the government, hey, you know what? I know I overstayed. I know that I illegally entered, but please forgive me. I still want to get a green card because I have family members in the country. So that's basically the purpose of the I-601A waiver.
So do I have to leave the US with this I-601A waiver?
Yes. So what happens with the I-601A waiver is, let's say the government looks at your application, looks at your case and says, oh, okay, we'll forgive your unlawful presence even though you overstayed your visa. We're going to let you get LPR status. However, we are not going to let you do it in the US. You have to go back to your country, and then you have to go through the consular process, meaning go to the embassy or consulate of the US in your home country, and then do the application process there, the interview process there, and get approved there. And then once you're approved, then you can come back to the US. So yes, the answer is you have to leave the US, but hopefully it's only going to be for a short period of time. For our clients, we've had clients who have done this process. They are out of the country for only a few weeks just to do their application and their interview, and then after it's approved, they get to come back to the US.
So can I apply for this waiver outside of US?
The I-601A waiver is a waiver that you have to apply for within the US. You apply for it in the US, you wait for it to approved while you're still in the US, and you leave the country only after it's approved. The purpose of the I-601A is to let people wait for the adjudication of the application still in the country so that they can be with their family members. So please, if you have an I-601A waiver, if you're going through this process, apply here, wait for it here. Don't leave until it's approved. Don't leave until your attorney tells you that you should leave.
Yeah, you should find some lawyer already done this and have a lot of successful case in the past. They might be able to help you on this process.
Right. And, our firm has done this kind of case a lot before with a lot of success. It's just a little complicated, but with the right kind of lawyer who has the right kind of experience, it's going to be a smooth process.
So who can apply or who can file this I-601A?
So the I-601A, like I said, is for folks who have unlawful presence, but it's not, it's not automatic. You can't just say, hey, USCIS, please forgive my unlawful presence, you have to meet certain qualifications. And those qualifications are, number one, you have to be physically present in the United States, which we already talked about, right? You have to apply for it while you're here. Number two, you have to be at least 17 years old when you apply for the I-601A, which, applies to most of the people who are probably thinking about this. And three, you have to have an immigrant visa case pending with the US Department of State. What does that mean? That means typically you already have to have the approved I-130 from your family-based petition, and that I-130 should have already been forwarded to the Department of State so that they can begin processing the next stage of the application, which is your consular processing part, meaning you already have a family-based petition, it's already current, and current is something that we talked about in the last YouTube show. It's already current, and the Department of State is ready to process your immigrant visa.
So besides I-130 petition you mentioned, is there other kind of petition that you can use as a base to file the I-601A?
Yes. So it's not just the I-130, although that's the most common one that we talk about. That's the most common one for our viewers that they want to know about, that the family-based I-130 petition. But you can also use an I-360 or an I-140 via your employer. Any type of visa petition can be used for the I-601A. Or, for very few of the viewers who follow us, if you also got your visa through the diversity visa program, you can also apply for I-601A, even though that you don't have an I-130 if you got it through the DV program.
We mentioned some requirement for this waiver, right? Is there other requirement?
Yeah, so we talked about physical presence, we talked about being 17, we talked about having a case with the DOS, meaning having an approved I-130 that's been forwarded to the DOS. The last and the most important thing is you have to have a qualifying relative who will suffer hardship if you are not allowed into the country or if you're not given a green card. What does that mean? Let's talk about qualifying relative first. You have to have a US citizen or a lawful permanent resident spouse or parent. So let me say that again, US citizen or LPR, spouse or parent.
Only these four type of people.
Only these four. Children do not count as qualifying relatives. Now, if you have children, if they impact your spouse, which they probably do, right? If their hardships impact your spouse, then you can mention that to USCIS. And then let's talk about the second part, which is hardship, meaning they will suffer without you, meaning they will have a hard life without you. And
what kind of factor going to be count in as hardship?
Right. So, when you hear hardship, you think about a lot of things, but typically that means financial hardship. They're not going to have enough income. They have too many expenses. You can also think of it as medical hardship, meaning they have health conditions, medical conditions, either physical or mental, that can make their life harder, especially if you are not there to help your relative, right? You can also think about emotional hardship. Of course, like if you're US citizen, spouse or parent, or LPR spouse or parent, and you are separated, emotionally that's going to be hard for your relative, right? And it might cause some emotional distress and some psychological distress. That's also a form of hardship. Another type of hardship is the hardship outside of the country. For example, if you are deported, your spouse or your parent might have to go with you back to your home country because, some family members are inseparable. Like if you're there, your spouse is going to want to be with you or your parents are going to want to be with you. And if they're at their home country together with you, they might suffer hardships at the home country. Maybe, their income is not going to be as high as it is in the United States, or maybe their healthcare is not going to be as good in the home country as it is in the United States, or maybe they will, suffer from some persecution. Maybe they came here as an asylee, and then when they go back to their home country, they're going to be under threat of persecution. So these are all like types of hardship that a relative can suffer. And if you are able to show those hardships, the more of those hardships you can show to your qualifying relative, the more likely it is that your I-601A waiver will be approved.
Yeah, you should find a better alternative like us to maybe give you some idea what kind of document or what kind of situation you're going to face, and then we can help together to maybe gathering and see what you're going to face. Victor, actually today the time is up. So
wow.
yeah, so you guys can feel free to leave your question with us on YouTube.
Right. And again, we try to answer as many questions as we can. Please send them over. If you didn't hear your question today, we might do it at some other episode. Just keep watching. And like I always say at the end of this show, these are only like opinions based on my experience. This show does not count as legal advice. It doesn't create an attorney-client relationship with any of our viewers, but if you want to be a client of Wang Law Office, please feel free to contact us. You have our information on the YouTube page. You can communicate with us through YouTube, through Line, through email, through whatever convenient is for you.
Yeah, you can continue to follow us on YouTube or just call our office number. Thank you. See you next time.
Bye.